The topic chosen today to speak on is on public interest litigation. I'll try and keep it as informal as possible. Many years ago, when one had just started practice, even I had no concept what public interest litigation was. And in fact, a client had once come to me and said, "Ye public interest litigation, ye kya hai? What is all this?" So I said, "You know what, honestly, even I don't know." I said, "I better, look it up." So then I started looking up and researching about it. And it was absolutely fascinating. The origins, as we know it, of public interest litigation actually goes back right at the time in the ages where you had the panchayat system, where actually somebody would come with a case on behalf of another person and say that this is what has happened and this is in the interest of the village, etc. That has not been sort of recorded or put in the annals of legal history. But in the modern era, the first real area of public interest litigation was in the United States. And that was a very interesting case, a case where a person said that he was insolvent or a pauper. He wrote to the Supreme Court of the United States saying that I don't have the money, I cannot, I can't hire a lawyer, and I'd like somebody, since legal aid is not made available to me, I would like to represent myself in the case. And the Supreme Court of the United States debated this, and with an overwhelming majority, actually allowed him to represent himself for the first time. And that perhaps is the time where, for the first time, this person represented not only himself, but the whole issue about can a person without legal rights or an insolvent actually represent himself personally in a court of law. So that was one. In India, if we look at, probably it was the 1970s when an activist wrote a letter to the Supreme Court of India and saying that there were certain illegal mining activities happening in the Doon area, the Doon Valley. And that letter of his got converted into a public interest litigation by the Supreme Court of India. And the Supreme Court then, passed directions. And the Doon Valley case, as it is now called, is probably the beginning of, environment protection directly, where the Supreme Court has intervened, and perhaps the first real case of public interest. I'll give you sort of the examples where, as a young lawyer in 1997 and 98, actually, I appeared in my first public interest litigation. In fact, this time it was not sort of for the petitioners, but it was for the respondents, interestingly. This was called the Smoke Affected Residents Forum case. I don't know how many of you actually remember. There was a huge problem that used to be of our public transportation. You had the taxis running on old and very outdated diesel engines in the city. And similarly, this actually started with Mr. M.C. Mehta in Delhi, established lawyer, who went to the Supreme Court and said that, the Blue Line buses and others, they were emitting pollution far more, vehicular pollution far greater than the norms, and that this, should actually be stopped. So the Supreme Court took it up and started passing orders and started monitoring the vehicular pollution in Delhi. And that is when they suggested that CNG should be introduced. So this group of residents from the Chembur area in Mumbai actually then followed that up and filed a petition, and that was called the Smoke Affected Residents Forum in 1998. And in that case, actually, it revolutionized the entire transportation system of our city. So all the taxis and auto rickshaws and everybody had to, despite there were a lot of protests and lots of strikes and lots of things, but finally they all converted into CNG. Now, it was very interesting because my senior, Mr. Firoz Palkiwala and I were briefed to appear on behalf of the BEST. And in fact, when the matter came up, we found that, initially the court was that if you do not convert to CNG, we'll shut you down. Somehow we managed to convince the court that BEST was definitely, far cleaner than it looked. But please give us more time, and slowly, we will sort of, get the engines changed. You'll be very sort of interested to know this. BEST, I don't know about currently, it used to have a fleet of about 3,500 buses. And because of the amount of running that it did, they used to change the engines literally every 6 months. So you would have a brand new engine every 6 months. And that actually helped. And, the court was convinced, and it gave enough time, because in those days, CNG was very, very, the CNG gas is actually a byproduct. It gets thrown into the air, and that was actually used. But the mechanism or the equipment had to be imported from Italy and other places, and that was frightfully expensive. So it took some time. But however, over a period of time, I think now not only the entire bus fleet was converted into CNG, but now we have them slowly moving to the electric version. And I remember many years later, the legal manager of BEST actually coming and saying that, "Sir, thank you very much. You saved us. Otherwise, BEST would have shut down." So the intention of the court was not to shut them down, but the intention was to move them from an unclean, diesel sort of fumes to a much cleaner variety. And, it's very interesting how that happened, sort of. And today, we've been able to, and we've seen this not only in Mumbai, but in several other cities. So interesting sort of way. That was my first introduction to public interest litigation. Of course, after that, another very interesting, also Bombay related issue, a orthopedic surgeon, one Dr. Sarosh Mehta, came and met me. He had come down. He was a very, prominent surgeon in London, and he used to practice there. He came down and he was traveling by train. And at Rajwadi station, the train stopped, and he got down and he found that somebody had actually fallen off. And he was absolutely horrified on how this victim was actually picked up. The stretcher did not have even a sheet, a cloth sheet. It had paper, and the victim was literally, picked up in a manner in which he probably would have, lost another limb, and then rushed, put into an auto rickshaw, and that was the last he saw of that victim. So he was so disturbed that he went to the railway commissioner's office, and he asked him. And these were the days, please remember, this was before the Right to Information Act came into force. He went and met the railway commissioner, and he said that, "Sir, please tell me, what is the rate of persons falling off from your suburban railway in such incidences?" And the ratio that the railway commissioner told him absolutely stunned him. They said that out of every 2 people who fell, only 1 survived. So can you imagine? There used to be 10 deaths a day at an average. So Dr. Mehta went to a lawyer, filed a petition. The petition, initially, what happened was his lawyer could not sort of reach the court on time. It got dismissed for default. He spoke to the staff of in the High Court, saying that, "This is a petition and this is so important. What do I do?" So the staff, most of whom used to travel by the suburban railways themselves, said, "Nahi, aap jaiye, go and stand and put your hand up and see what the court said." So he went and he did that. So I think it was Justice B.P. Singh's bench that time. They asked, "Yes, doctor, what can we do to help you?" He said, "Sir, this is..." First it was asked, "Why did you come to court?" He said, no, sir, court is very powerful. They can do many things. So they laughed and they said, okay, we will restore the petition. But doctor, you need to come to us with facts and figures. So apparently the petition was restored and the case went on. Then the High Court dismisses his petition on a ground saying that the overpopulation of the city is not the concern of the railways, and his petition was dismissed. That is when he came and he met me saying that we need to, go to the Supreme Court. I said, there's no need to go to the Supreme Court. We'll wait till, in fact, I found that both the judges were likely to retire. We allowed them to retire. We filed a review. It came up, and I think Justice Chandrachud was part of that bench. And we said that, this line of, the overpopulation of the city is the reason for the deaths on suburban railway tracks is absolutely not, the right way, and this court must review its order. The court did that. It was restored. The case went on till, I think, 2018. In the meanwhile, first till 2006, and that was very important. 2006, if you remember, there were blasts at the, our railway stations in June or July. And we went to court again saying that, in a medical emergency, you can't have, the railway authorities running away. In fact, when the blasts occurred, the railway authorities themselves ran away, and the victims were left to, the help and assistance of people who just came forward, who didn't know what emergency medical, treatment was. So the court then intervened and they put a full medical emergency plan in place. Then the question was that we don't have clinics on major railway platforms. That was introduced. Then, if you remember, there was that, I think it was at Elphinstone station where the entire sort of, bridge collapsed and, people lost their lives. That was also taken up, through the court. I've even traveled with the engine driver, and they were also, some of them suffer from post-traumatic stress disorders, because what happens is as the train moves, people cross the railway tracks and there's nothing that they can do. They can't even stop. They said, if I stop, the bogies at the back will derail. So we had to do all these things on the simple principle that the golden hour principle meant that in the first 1 hour, a victim of any accident, in this case a railway accident, must get treatment in either a public or a private hospital with immediate effect. So then, of course, our other good friend, Samir Zaveri, an activist who had lost both his legs during a railway accident, he filed a petition saying that Dr. Mehta's, in his matter, several orders were not being followed by the railways. That got taken up. I got appointed as the amicus in that matter. And I think finally, after almost 18 years, we finally concluded this long litigation on our lifeline of our city. This then takes me to another case which is very similar in nature. What happened was Advocate Punalekar, his father wanted to have a surgery, and he wrote to the private hospitals. He said that under the Bombay Public Trust Act, you are supposed to keep 10% of your beds free for poor and indigent patients, and my father falls under that category, and he would like to have a bed which is reserved for such patients. He wrote to several hospitals, all of whom come under the office of the Charity Commissioner. Nobody responded. So he then filed a petition that came up with Justice Dalveer Bhandari and Justice Chandrachud's bench. I read about it directly through the newspaper, where I found, I think this was in 2004 or 5, where I found that they had appointed me as the amicus. So that's another, very strange system where the court appoints you directly and you get to know sometimes through the media. So anyway, we took up that matter. What we did is we met the charity commissioner at that point of time. He was a retired principal judge of the city civil court. And he said that this is a very, very huge problem. We must find a solution. So what he did was, very cleverly, he sent one of his staff members in, wearing slightly torn clothes to one of the hospitals to see if they were giving admission or not. Unfortunately for that hospital, they called the guards and threw this fellow out. We filed his affidavit and went back to the court and said, this is the way people are being treated and therefore there should be a stay. What was happening was the private hospitals were getting a lot of benefits by way of tax exemptions, customs duty waivers, etc., on equipment which were meant for poor and indigent patients, and they were not using it for them. So the court granted a stay. Then all the hospitals and all their, the senior administrative staff came and met, and they said, oh, I'm Major General so-and-so, and I'm, we are doing charity. I said, see, as far as the court is concerned, I am Field Marshal or amicus curiae in this matter. And it's very clear that you are not, but let's sit down and find a solution. So we did sit with them, a scheme for poor and indigent patients, which meant that 2% of the hospital's monthly income was set aside and kept in a poor and indigent patients fund. And that money was then utilized for poor and indigent patients when they came to the hospitals. The beds didn't necessarily have to be kept vacant, but admission in case of any emergency in a private hospital is now mandatory. So if something happens to someone, please don't hesitate. You can go to any hospital. You don't have to sort of be taken necessarily to a government hospital or a railway hospital. So this scheme that was formulated was then accepted by the government under Section 41AA of the Public Trust Act. And it became, a part of the law. So today, if you go to a hospital and you find a board, usually close to the emergency department, saying how many beds are kept aside, that was because of this particular litigation. So, and because please remember, in India, we still don't have social security for poor and indigent patients. That is another very fine example of how a public interest litigation helped in our city, which is Mumbai. Then, interestingly, the issue of disability, persons with disability. What happened was there was this, the former Spastic Society of India, now called ADAPT, that is able and disabled persons all together. In fact, two of the members of ADAPT actually met us. The late Gerson Dikuna, and we used to actually go. There was an organization called Agni, which was Action for Good Governance and Networking in India. So they were setting up resident associations throughout the city. And we had gone for a meeting in, I think it was in Chembur or one of these areas. And these one lady and a gentleman, both on a wheelchair, met us there. And they said, this is great. You all are trying to form resident associations and, improve the sort of street infrastructure and footpaths and other things. But what about people like us? I said, I thought to myself, I said, they're absolutely right, and something needs to be done for them as well. Well, that opportunity came in a very interesting, way. In 2002, students of the ILS Law College in Pune, they filed a public interest litigation saying that the 1995 Persons with Disabilities Act, especially with regard to buses and public transport, was not being adhered to. And that time, I think it was Justice A.P. Shah, he granted a stay saying that all public transport buses must conform to this particular rule. Then these students, obviously, they said that we were up against, the state government and we're finding it very difficult. So they approached ADAPT, and ADAPT actually, they called me. We had a meeting with the students at that time. Of course, Mr. Ravi Prakash is now a very leading lawyer in the Supreme Court, but that time he was a student. And I said, okay, I said, we'll intervene for adapt and, sort of assist the court from the persons of disabilities perspective. So we did that. And that day was very interesting what happened. That, the taxi in which both Mr. Singit and Ninu Kevlani, who were both on the wheelchair, they were applicants. They were allowed inside the High Court. As you know, High Court is like a Gothic structure. They were brought to the ground floor. They stepped out of their taxi or vehicle. Then, they were sort of physically lifted and then taken to the ground floor, then the first floor for affirming their affidavit, and then to the Chief Justice's court. It took them almost, I think, close to an hour. Luckily, the case was in the afternoon. So when the matter reached, of course, I mentioned, I said, we are intervening. Intervention, of course, was allowed without a problem. Then I told the court that, I must bring this to the court's attention. I said that the applicants, I said, they took them almost an hour to come to court. I said, we all pride ourselves as, being the best court, this side of the Arabian Sea. I said, pardon if I'm, sound contemptuous, but I mean, we are seriously lacking any infrastructure for, persons like these. How would they come and approach this court without proper infrastructure? So first the court sat up and they discussed among themselves and they just said, okay, we'll look into it. I was waiting in the court for another matter. And I think 2 or 3 cases later, the Chief Justice and Justice Chandrachud called me back to the podium. And they said, we've considered what you said, and we've informed the administrative authority, that is the protonotary, to immediately allow the use of the judge's entrance for such persons with disabilities until adequate infrastructure is made available. That, obviously got picked up by the press and everybody else, and it kind of showed that judiciary was quite sensitive to problems like this. So that's what happened. It didn't end there. I think about a month or so later, my advocate on record came running and started laughing. He said, just see, you were shouting about getting a ramp done in court. Just see what they have done. I was absolutely horrified when I saw they had cement concreted some steps. They had put a rickety railing and they had said, this is a ramp. And, I went back to the Chief Justice in open court and I said, I'm really sorry. An able-bodied person will get a high percentage of disability if he uses some, thing that they put up. So the Chief Justice that time called me to his chamber. He said, Mr. Mistry, what is to be done? I said, please demolish this. I said, let us get something properly done. I said, we got in touch with an architect. Then they had a meeting with the PWD, that is Public Works Department, and the concept of actually setting up, because in the 1995 Act, ramp railings and toilet blocks in all public buildings were mandatory. It took again, I think almost 6 months thereafter, and in another petition, I was arguing and I brought it to the court. I said, just see, what type of a high court do we have? Even, despite coming to the court time and time again, we find that there is no ramp or any infrastructure available for disabled person. Justice Dalveer Bhandari was the then Chief Justice. He immediately called for the file, passed an order and said, you must have a ramp made, for such persons with disability. It got done. And I think the first time ever in our court's history, both the Chief Justice and I think it was Justice Chandrachud, they came out, spoke to television outside, and the ramp was inaugurated. Well, it's another story that the toilet block that was constructed was demolished for some reason, but now again the High Court has taken cognizance and that is being restored. So it is always been sort of 2 steps forward, 1 step back, and vice versa. But that is what happened. This issue of persons with disability sort of took another very interesting turn. I actually appeared against my own school. And you would say, why would you do a thing like that? Well, because in those days, for learning disabilities, that's dyslexia, dyscalculia, and dysgraphia, learning disabilities were not even considered a disability under the Disabilities Act. And 2 students, one from the Atomic Energy School and one from another school, I won't name my school, but it doesn't matter. The 2 students were actually thrown out, and they went to court. I had appeared for the Counselors Association, and again, with the assistance of professionals, the scheme for children that suffered from dyslexia were drawn out, and as a result of that, extra time and so many other benefits, including taking special subjects in their final years and things like that. All that was sort of made, was drawn out, was tested in court, and then that became a part of the curriculum, and I think that has benefited a large number of students, not only in Mumbai but even across India. So that was very interesting. We had actually then a similar petition, and it's interesting how law students pick up these petitions and file. So I was asked by students from the Salgaonkar Law College to appear in a similar petition, which was filed in the Bombay High Court bench in Goa on persons with disabilities. And there actually something very interesting happened. We had then Justice Lodha, who then of course became the Chief Justice of India later on. He was sitting, and I appeared before him, and he said, what's going on? I said, Act of 95, we are in 2005, and absolutely nothing has happened. So he summoned the Secretary Social Welfare Department the next day. In fact, he said if he doesn't appear, I'll issue a non-bailable warrant against him. He made the poor gentleman, stand in the box and explain, why the act was not being implemented. And subsequently, again, we sat down with the NGOs, a Goa state policy for the persons with disabilities was framed. And interestingly, the same gentleman, the Social Welfare Department, he called me, I think, a year later, and I thought there was a problem. So I said, yes, how can I be of assistance? He said, no. He said, I'm going to Rashtrapati Bhavan because I'm receiving a prize or a citation for the most disabled-friendly state. So it's so interesting that if the court is able to change the mindset of one officer, what magic he can do, and change and get Goa, of course being a small state, but at least a lot of things done. That state policy for a very, very long time was something that we referred to not only in Mumbai but even in other parts. So that was interesting. There were other issues like the gentleman with the cleft lip who had several operations and he couldn't eat, and although this was not covered under Persons with Disabilities Act, we got the court actually to expand the scope of the definition and covered that as well. And he got his disability certificate at that point of time. You'll be very interested to know that the United States has a position, an advisor to the President of the United States, who is an advisor on issues for persons with disabilities. Unfortunately, we have a state coordination and a central coordination committee, but no such advisor yet in India. One other very interesting issue, and this is the last one on persons with disabilities, was the issue of the Mumbai Marathon. They actually had barred wheelchairs from participating in the Mumbai Marathon. And I remember we wrote to Standard Chartered, who was their sponsor in London, as well as I think Mr. Sunil Dutt at that time was the sports minister, saying that how can you have a marathon where you keep such an important, segment of the population out? Because one of the rules said that wheeled vehicles and animals not allowed on the course, and taking umbrage under that, they were refusing. So the minute we wrote, and of course a copy went to the disability commissioner as well, they immediately came back and said, no, we are so sorry, and this is something that we had completely missed, and they restored the race, and every year the marathon with the wheelchair race has now become apparently one of the most popular segments of the events. So again, very interesting way in which sort of a pre-litigation move actually helped in restoring the rights of persons with disabilities. Articles in newspapers also, that's another very interesting issue. If you go to court sort of showing a particular article and the court takes it up in its suo moto capacity, we've had several such instances. One instance was where a bonded labor was actually killed because he could not pay 50 rupees back to his employer, and that was reported in the newspaper. We showed the then Chief Justice and said that this is absolutely terrible what is happening, and why don't you please take it up? Well, to the credit of the Chief Justice, it was immediately taken up that afternoon, and as a result of that, the widow got compensation. The labor commissioner and the rules for bonded labor were also gone into by the court, and I think that is helped the sort of the public at large. One case that I had done, which of course I think sometimes comes up, I now believe, as a moot court problem, was the case on abortion. That is Nikita Mehta's case in 2008. That was also very interesting, and although it was not technically sort of in the realm of public interest litigation per se, but it sort of brought out the rights of a lady, and whether the important question of whether to abort or not. What had happened was, in fact, it was not my case at all. It was another lawyer, and he was not available for that particular week. And then they came to me and they said, this is what the issue is. So the Medical Termination of Pregnancy Act basically says that, or at least that is what was in 2008, that anything over 16 weeks used to be a criminal offense. So the doctor, the nursing home, the hospital, everybody could be, if they went ahead and performed the abortion. The doctor at that time, Dr. Datar, came to us and said that there's a lot of illegal abortions which are happening, and we need to. And he said, I have this particular patient, and there is an issue because there is a hole in the heart of the fetus, and I feel medically that even this endangers the life of the lady. So, well, I picked up the Medical Termination of Pregnancy Act for the first time, read it. I told the doctor, sorry, I don't think we have a case at all. I said, but let us see, let us try. And I said, let us look at foreign precedents. Let us see what other countries are looking. So we found that in England, for example, they did allow right up to 24, 25 weeks. We went to court, showed, expressed this. The court quizzed me, they quizzed Dr. Datar, and then finally they said, okay, let her go for examination and things like that. This matter suddenly assumed a lot of importance, and from news channels to everybody started sort of following. Case sort of also went into the judge's chambers. We were told that if medical and financial assistance is given, would the lady still want to, abort? Dr. Datar was very clear. He said, no, medically she has a problem. Then the committee that we had suggested, they couldn't come to a conclusion. And then, of course, finally, I think in the next week, I was not available, and somebody else appeared. The court said that no, we cannot look into this issue. This is a question that should go before the legislature or parliament. And then, of course, whatever, the lady sort of she lost the child, but she was fine otherwise. The interesting bit is, several years later, whatever we had argued in court, the government took up, and now it is law. And that is the other interesting part about sort of public interest litigation. That at one point of time, you might find that the court is totally against you, not possible, can't be done, legislature, and all the rest. And few years later, the mood changes, and suddenly it becomes a part of exactly. And you sometimes you wonder that if they'd sort of done the same thing a few years later, like in this case, would would the sort of the abortion have been allowed or not? Anyway, that is a matter of conjecture, and that is for everyone else to look and consider. Another interesting change that happened. Of course, what is the public interest litigation? How is it filed? Yes, I've forgotten to touch upon that. So usually in the High Court, you can file by way of a petition on the original site. That is, if it affects the city, etc., or the appellate side. So under 226 and 227 of the Constitution, or you can approach the Supreme Court directly by way of a writ under Article 32, where certain questions of law are, being and usually these matters are being heard in most of the High Courts and the Supreme Court by specially assigned benches, usually consisting of the Chief Justice as one of the members. And earlier these used to be filed just as in by way of regular writ petitions. We didn't have numbers like, so now if you see it be called PIL number so and so. In earlier cases, it used to be just writ petition. So these changes in the procedures were done. The other interesting aspect was the use of newspaper reports. Now, what was interesting was that sometimes the court says that a newspaper report can be relied upon. It gets converted into a public interest litigation or suo moto petition. But sometimes if you refer, they say, oh, no, these are merely newspaper reports and there is no sort of evidence. So that's an interesting balance that you either as a public interest sort of petitioner or as a lawyer appearing need to keep in mind. And you need to convince the court that, yes, this is just the beginning, this is the first step, and therefore, newspaper reports, if it is from a credible source, it should be, permitted. Usually, in the steps of filing a public interest litigation, just as you have in other forms of litigation a legal notice, you send to the authorities that you want to involve in filing of a petition. It is a legal notice for all practical purpose, but you call it a demand for justice. And that is why if they do not respond or they respond in part, then you can invoke the 226 or 227 of the Constitution or 32 saying that they have not responded adequately to your demand for justice and therefore you are approaching the court. So that is, very, very important and interesting. I have argued in, several, for another very interesting petition was for beach safety. So many, people used to visit sort of beaches, not only in Maharashtra, but even in Goa, you go, enter the waters, and then, the tide pulls you away, and there are deaths. So the whole concept of getting lifeguards on the beaches, and again, this was the result of a public interest petition which was filed, where a boat containing tourists had overturned in, I think it was in the Kandolim or the Kalangut beach area in Goa, and that forced the court to look into this whole issue of beach safety. And now, of course, today there is a full system of lifeguards, especially in Goa. I mean, Maharashtra also, it is there, but you do find a few gaps here and there, and I think that so you find the fact that it is citizens who are bringing this to the notice of the court, and as a result of which the authorities are acting on these issues. Of course, a petition which is of course pending and is going on currently. I probably won't say too much, but I again on this whole issue of potholes and manholes, I was appointed amicus in, I think, 2016. A judge of the Bombay High Court wrote a letter to the Chief Justice saying that people have lost their lives, and today we are at the stage of contempt petition being heard, and the court is looking into this issue of why we cannot have sort of good roads and footpaths and other aspects of our city. I don't think I'll say too much on this matter because it's pending, so that's why excuse me for that. Another petition that again where a sea of change has taken place in on the use of technology so I have also had the privilege to sort of practice law in Canada, and I had noticed how their courts and their systems function. So in 2017, when Indira Jaising, a senior advocate of the Supreme Court, and of course, I think the senior most lawyer today from the Bombay High Court, lady lawyer, she filed a petition saying live streaming of cases is the way forward, and that is, it will bring transparency in the system. Through a school friend who has been a habitual litigation because of family disputes, etc. We filed an intervention saying that it is not enough to have only live streaming, but we should also have what is called transcripts. Now, what are legal transcripts? Transcripts is basically an audio sort of recording which then gets transcribed into words, and you, because today in court, and you can imagine what you say in court earlier never used to get recorded. So today we are recording what I'm saying so that both I can refer back to it and you can watch it at your leisure. Similarly, we found that transcripts were not being used. Now, we did a lot of research on this. Of course, we found very interesting sort of data on how transcripts were used in other countries of the world. But I must tell you that in India, the first transcript that I found was in 1908. Yes, 1908, in the Bal Gangadhar Tilak matter. And in para 27 of that judgment, for the first time, I'll be happy to look at anything prior to that, but if anybody finds it, I checked with people who curated the museums in the Bombay High Court and Supreme Court. They were not aware of this. So the first time that an order showed transcription was what we found in 1908. In those days, of course, there was no question, there were no typewriters, there was nothing. So it was all handwritten. So then we compared that to the legislature. And legislator, if you know, assembly and your parliament, all the proceedings are recorded. So we said, how did they manage to do that? So we found that they used to use stenographers and change them every half an hour for accuracy. And that's how they used to record very accurately the proceedings. So we argued this, and of course now in the celebrated case of Swapnil Tripathi and others, the Supreme Court said that sunshine is the best disinfectant, and they've said that live streaming of cases, both for constitutional matters, and now the Gujarat High Court. In fact, very interesting. In Gujarat, they're going to have live streaming right from the lower courts upwards, and I think most of our other courts will follow. So from Andaman and Nicobar Islands to the Jammu and Kashmir High Court in Leh to others, technology, and of course, I'm sure you must have all read that the Chief Justice has called up other courts saying that you must have the hybrid system that was used during the pandemic to and permit people to appear in a hybrid mode. So I think we're going to see that the E-Committee of the Supreme Court, we'd actually done an experiment using an AI app showing how transcripts could be used and how accurately they could be used. And in fact, very interestingly, one of our colleagues who's a barrister in Pakistan, he took all the our petitions, and interestingly, even the Pakistan Supreme Court has started, live streaming of their courts. So, I think at the end of the day, if you have transparency, if you know what has happened in court, and one of the other, great courts to look at, if you all have the time, do look at the International Court of Justice. There you have live streaming, transcripts, and translation. Translation is also something that we are going to be seeing in India, very, very shortly. The judgments and everything will be translated in different languages, and I think that's a great, step in the right direction. So I think I've taken a lot of your time. There's a lot more that can and will be said. Yes, before I end, I think one important aspect, there are rules for public interest litigation now. So you must be aware of those rules when you file. And, quite often when somebody does file and is not aware of the High Court and Supreme Court rules, then, your petition gets dismissed on technical grounds. Please look into those rules and see whether it falls within those ambits or not. And on the issue of, frivolous public interest litigation, I think, I have a very sort of different view. I think the courts are very well equipped. They know what is frivolous and what is not. So, if somebody does try and file publicity interest of frivolous litigation, the courts are very well equipped to take care of that. So yes, I pause now and happy to take any question.
Hello, Jamshed sir. Specially thanks to you because you appear many petition for disability person. I also disabled person. So I have basic questions. So the public interest litigations, is the applicable any NGOs, because this NGO work specially special community. So is the applicable there?
Your question is that, is there any NGO that is sort of, is it required? So I'll answer it in two ways. One is that, do you require an NGO to file, or can you file it on your own? Is that your question?
Yes, sir. I want to file NGO.
Okay. So an NGO is what? Is a non-government organization. So you have to either a trust or a society under the Societies Registration Act, or now you have a Section 8 company. So yes, an NGO can take up an issue which is for in public interest. There's no difficulty at all. But you can, as an individual, also take it up, or even a third person who has no interest, no
नहीं
direct
सर,
interest.
एक्चुअली मुझे मुझे ऐसा कहना है कि जो अगर समझो कोई एनजीओज है जो स्पेसिफिक मतलब कम्युनिटी के लिए काम करती है,
जी,
जैसे कि अभी डिसेबल लोगों के लिए एनआईएच है, नैब है, ऐसे
हाँ,
कई सारे एनजीओज काम करती है। तो
जी।
क्या उस एनजीओ के खिलाफ हम पिटिशन दाखिल कर सकते हैं क्या?
एनजीओ के खिलाफ
या
now NGO is not an authority, is not a government. So you will not be able to
ओके
file a public interest litigation. You will have to file a private
ओके
suit.
ओके 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 सर।
I'm Advocate Nidhi here, and I'm very much interested into getting into PIS because I have certain topics and that I need to just present before the court. My question is, sir, you talked about rules. You talked about rules of High Court and Supreme Court. So, how a person who's very fresh to the court can understand those rules? Is there any kind of library which is having all the suit which have been filed earlier, the litigations that have been filed earlier, where we can get to see that how and what we should take care. How you want me to go ahead?
So two things you can do. One is that these rules are available. I mean, if you do even a regular check on the web, you put in the correct words and you will get the rules both for Supreme Court and High Court. You can also do, today you have very good free sort of legal databases. You can do your research and check on, say, put in public interest litigation and cases that have been been dismissed. Look into that category. You will find why cases have been dismissed on what grounds. See, I'll tell you one thing. It's very simple. You can be rest assured that the courts now, I mean, the judges especially, they are very, very aware of if, of these topics. To help you, basically, if you have, what a regular writ petition is, right?
Yes.
Right. Now, there are certain changes and amendments to that you have to make. That then will fall under. There are certain clauses that you have to add to say that this is in public interest, etc. And then you file, even if it is not absolutely correct, or ideal. We find that a lot of leeway is given by the court because they go by the subject matter, they go by what the issue at hand, and they don't go by necessarily the technicalities. But it should not be that, for example, and usually the problem arises is that if you are a front for a private interest body, that is where usually the trouble lies. And if the court finds out, then they dismiss it and they impose costs.
Okay, so it says that my litigation should be presented in a manner that how it is going to affect public at large, and it
Absolutely.
should nowhere represent that somewhere I am going to get benefited in any manner from it.
Correct, because that is the whole the basis of pro bono litigo is that I am coming to court with clean hands. I am coming to court for the benefit of others
Yes.
who cannot come to court, and so you're like the representative of that particular category of persons. Yes.
Okay. Okay, so thank you. Sir, one more question. Maybe it could be a crazy question, but can we consider Mother Earth as one of the litigator?
For that, you may have to approach the international court, but
Okay.
no, as of now. But I don't know. I mean, if what is it called? If Ram, Lalla, and they are considered as a legal person by courts, Mother Earth could be, but then just do your research and make sure that you go before a court who understands what you're trying to say. Otherwise,
All right. Okay, so matlab, I have to do complete research because environment, I want to take one subject. So depletion of environment. So in that means making.
So even for the environment, you see, there are two aspects. One is, of course, not only the. So another issue is that sometimes, apart from a public interest litigation, you also have the can use for environment the National Green Tribunal.
Okay,
That is yes, NGT. So if there are pure questions only of environment, because they also have the powers of the High Court. So you can, of course, if it's a mixed question, then High Court. Otherwise, NGT is also a lot of work now goes to the NGT directly.
Okay, sir. Thank you, sir. Thank you so much.
Sir, good evening, and thank you so much for your candid, expressing the forum and enlightening us. Really appreciate your professional journey. The question is, sir, I believe strongly that justice delayed, justice denied. And, so many, even PILs are taking a lot of time and pending. So two questions in that. Can we file a PIL for expediting the court process, making faster, remedy or reaching to the decision? And if there is already an existing PIL, like you said, the portals and all, which is very sensitive and, should be seen rigorously or seriously on fast track, can we file a PIL to expedite one pending PIL?
So I'll answer your second question first. Remember, when you file a PIL, you are actually technically jumping the queue because you are expecting the court to fast track, and because it's an issue of public importance. And that is why, certain courts, for example, the Bombay High Court, the bench of the Chief Justice takes up, PILs on a particular day, on Wednesday itself, the whole day. The question of, and therefore you can always, make an application for urgent listing, or so that is always there. You see, unlike your civil procedure code, where in the rules they say that technically you're supposed to finish a case in 1 year. That probably doesn't happen, but at least there is a direction. But so far in public interest litigation, there is, no such timeline that a case has to get over by a particular point of time. So that is not there. So it then depends upon, again, there are 2-3 ways of actually getting things done. One is there where if the court is monitoring, then even at the interim or the ad interim stage, as we call it, the case keeps coming up and the court keeps, passing directions. The other option is that it is heard finally at the admission stage. So these are all, little, I wouldn't say tricks of the trade, but the methods, and that is where, your lawyer is the best person who can advise you on this.
Thank you, sir.
How can one ensure that a public interest litigation petition does not get rejected?
By doing research, by being honest with the court, and and taking up an issue which if genuine, a genuine, usually I have not seen. I mean, of course there are perceptions. You have to also understand that at the end of the day, the judges who are sitting there are also, human beings. Their perception may be very different. But by and large, if there are issues that are taken up and which are important, so research and, backing up your facts with research and good research is usually the key to ensure that, you should not rush to court immediately. That is the other important thing. Get all your, sort of facts, research, or also be very clear and specific on what orders you want the court to look into, or what orders should the court, be passing. You should then mold your reliefs accordingly and then file it in court accordingly. And usually, these, if you take care of these 2 or 3 things, the court Generally, I mean, we don't say we can't be 100% sure, but generally they are, and you should approach the court and be very, sincere in your approach. So even if there is, for example, if they find that you are not able to put across the case in a particular way, the court would appoint somebody to assist you either as an amicus or give you a lawyer, and that is seen quite often.
Okay. So the next question is, any alternate legal remedies to a PIL?
Of course. I mean, if you find that it is not in public interest, but then you have to find somebody who's interested and then file a regular, a writ petition or a suit, which is then will not be in public interest. So, I mean, you can file a suit against the government or the corporation. You have to, follow CPC, give them legal notice. Similarly, if there is a regular writ petition that is affecting, people, that can be certainly filed. No problem.
Okay. And so there is one more question. What is the future of public interest litigation in India?
I think the future is very bright. I think, the next generation of judges are, quite, well equipped. I think we should also be quite thankful to our system that, they are sort of open and receptive to public interest litigation. Certain countries, you will find that filing a public interest litigation, even in the Western world, is very, very difficult. Here, our Supreme Court, is sort of open to hearing matters from anyone. While in other countries, even Western countries, to get past their system, it is very, very expensive, and like the Supreme Court of the United States sits only, a few times a year, not like ours who sits, of course, we have more vacations than a lot of other countries, but apart from that, and if you notice, the Supreme Court is in the news all the time. So that is the interesting part. Is not a day in which a matter is not reported.
Okay, sir. So I think we are done with the questions. So thank you so much, sir, for such an insightful and such an illuminating webinar. It was a great pleasure to have you with us today. Thank you so much, sir.
Thank you. Thank you very much.